All right, we're back in session. Mr. Gaskins, do you have other questions?
Just a couple, Your Honor. and if I
Okay,
may
go
approach
ahead.
the witness.
Sure.
Take it from, we were talking about Laura's diary.
Yes, sir.
Let me take a look at it and make sure that you recognize it, if you will.
That is it.
Do you see in her diary that her last note in her diary was March 14th, 2011?
Well, there's more after that.
Would you look and see when the next entry is?
July.
She skips, so she's got an entry on March 14th, 2011. When is her next entry?
July 1st, 2011, I'll say that I do recall some breaks in the entries, but some of these pages are loose, so I can't say certainly if any of them fell out or not. But from what's here, March 14th, 2011, then there's a break until July 1st, 2011.
And if you will, flip over to July, the next page, July 5th, does she also make a note?
That's correct.
Would you read that note from that day?
Tuesday, July 5th, 2011. I dropped the boys off in Raleigh today at 4 p.m. with Grant the 3rd at their apartment. I asked Grant the 4th over the weekend if anyone touched his or Gentle's wee-wee, and he said no. They played, experimenting sexually near constantly. I asked because Grant the 3rd was molested. We had a good weekend, 4-day week. We watched fireworks, learned about space, compasses, and how popsicles are made. The boys got along really well. We used a system star charts that improved our interactions greatly. Both boys loved filling their chart up. Gentle was dry almost the whole time.
That's all I have.
Okay. Questions?
Yes, Your Honor. May I approach?
All right.
Had to follow up, State's Exhibit 831 that you were just reading from. You've just read the entry from July the 5th of 2011, is that right?
Yes, ma'am.
And with regard to, there's one last entry, is that right?
Yes, ma'am.
And that's July the 12th of 2011, is that correct?
That's correct.
And I'm not going to ask you to read that entire entry, but down towards the bottom of that, does Laura make reference to a recording that she's made?
Yes, ma'am.
And what does she say with regard to a recording?
She notes it's on recording number 53, side A.
And you indicate that you recovered her computer in this case?
Yes,
And it had multiple recordings on it that had been taken from a recorder and put on the computer, is that right?
as I recall, yes, ma'am.
But that one wasn't on there, was it?
I don't recall that one being on there.
And she has dated that 7/12/11. How has she written the date?
Set Tuesday, 7-12-11.
And in looking back through that journal, is she consistent on how she writes the date? In terms of dashes between the month, day, and year?
Yes, ma'am.
The note that was recovered from the apartment, did you note the date on that document?
Yes.
And how was the date written on that document?
It was 6, and then it was a slash, vertical diagonal slash, 13/11. Then the 6 was X'd out, and a 7 written above it with the initials LA.
And so the entries in that journal, which they begin back in 2010, there's a gap, but they conclude on July the 7th, I'm sorry, July the 12th of 2011, all of those dates are written with the dash between them, is that correct?
It appears that they are all, the dates are written the same way.
And only on the note do you see the slashes between the month, date, and year, is that right?
That's correct.
With regard to, may I approach again?
All right.
Mr. Gaskins was asking you some questions with regard to some phone records. He was showing you Defendant's Exhibit 37. I believe that's the same as State's Exhibit A79. Does that appear correct?
It appears to be the same, yes, ma'am.
Okay, and those are phone records for the telephone ending in 7651. Is that right?
Yes, ma'am.
And on line number 58, that reflects the outgoing phone call or incoming to 7651 from Laura's phone to the 7651 number at 4:59 on the 13th. Is that right?
That's right, yes, ma'am.
And you recovered, one of the telephones that you recovered in this case was that 7651, or the telephone that had that number connected to it. Is that right?
Yes, ma'am.
And you've indicated that number was associated with Amanda Hayes.
That's correct.
And why do you say that?
That was the information we had initially, was that the 8581 number was Grant Hayes's and the 7651 was for Amanda Hayes. But then when we, for instance, saw the cell dump, the cell brought phone dump, on this 7651 number, Grant's mother's number is saved in there as Grant's mom. And then on the 8581 number, it's saved in there as mom. So common sense, I mean, that would make you believe that this 7651 number was for Amanda.
And as the investigation went on and you got more information, did it appear that those numbers, or those telephones were used interchangeably by Grant and Amanda Hayes?
Yeah, they had a lot of the same numbers were being called by both phones. So gave it the appearance that both were being used by both Grant and Amanda.
And turning your attention to those records that you have in front of you, line 71 and 72 of those records,
Yes, ma'am.
do they show a telephone call from that 7651 number on the morning of July the 14th?
Yes, ma'am.
And do you recognize the number that's called, on what time is that?
The first one is at 9:48 a.m. and then the one right after that is 9:58 a.m.
And do you recognize the number that's being called from the 7651 number?
Yes, ma'am.
And whose number is that?
That's the number for Amanda's daughter, Shay.
And Shay Elmer's testified that she received a phone call from her mother, Amanda Hayes, that morning. Is that right?
That's correct.
I just have two more things. You had been asked by Mr. Gaskins about the AccuRent or comprehensive report and asked about some properties associated with Grant and Patsy Hayes. Is that right?
Yes, ma'am.
And I believe you indicated that those showed for taxes and for that 2010, 2009, 2010.
Correct.
With regard to the AccuRent report, does it warn you at the beginning that the information contained in there is often inaccurate?
It does, and I can speak from experience that sometimes the information in there is inaccurate.
So is that sometimes a starting place at the beginning of an investigation just to try to get some information?
And it may not even be a starting place. It's just one of the things that we commonly do to try to get some more information.
And on the front page of the AccuRent report that Mr. Gaskins put in front of you, does it indicate the data is entered poorly, processed incorrectly, and generally not free from defect? Any data supplied by this system must be independently verified.
That's what it says, yes, ma'am.
And that's under important, and that's the first sentence that appears under that, in the beginning of that report. Is that right?
That's correct.
The Detective Falk, finally, you, have testified about, these purchases and, these spreadsheets that you, created using the, information that you received from the banks, as well as some receipts and following through with those. Mr. Gaskins asked you about, ICE purchases. If Grant or Amanda Hayes had purchased ICE at some other location and paid in cash, is that something you necessarily would have known about?
No, no.
ICE sold throughout the city and many different vendors?
Yes.
Thank you, that's all I have.
All right, anything else?
Just a couple things, Your Honor. You have, Detective Falk, you have the telephone record for 7651 in front of you.
I've got the state's exhibit.
I think they're the same as mine.
Yes, sir.
If you will, go over to page 2. I believe Ms. Holt asked you, looking at call number 71, if a call was made to the number that you later identified as Shay's number.
That's correct.
And that call was at 9:48 a.m., correct?
That's correct.
And then she called her again at 9:58 a.m., correct?
Correct.
The next call she made at 10 a.m. was to the number 898895404. Do you recognize that call?
It looks familiar, but I can't recall whose it is.
Would it help you if you knew that that was Monkey Joe's?
That may be accurate.
Now, the next call that is made from that telephone number at 10:04 a.m. is a call from 7651 to Laura's telephone number, isn't it?
That's correct.
And the time that lapses would indicate that there was no answer, correct? Or do you know?
I don't know, and I think you had, I think there was somebody testifying before me who was be better suited to answer that, and he explained that there's no way to really know. But
Go over to the next page, if you will. At 10:30 a.m., there is a telephone call from 7651 to the 252 exchange. Do you see that?
yes, sir.
Is that a call to Grant's mother? Do you know? Do you remember?
I know that's a number for her.
And then the next call at 11:17 a.m. is from Grant's mother back to that cell phone number, 767651, correct?
From her number back to that 7651 number, yes, sir.
Thank you, sir. That's all I have.
All right, anything else?
No, Your Honor.
Thank you, I'll see you stand down. Thank you. Further items for the state.
Your Honor, this time the state rests.
All right, collect your items up here. And to the extent that some of them are the defendant's items, if you'll return them to Mr. Gaskins. Ladies and gentlemen, the protocol of the court requires that when the state has rested its case, I have to make a couple of technical decisions. Don't concern yourself about that. That's my job, not yours. I don't know how long it'll take. If it's going to take a while, I'll send you home. But if it's not, I'll bring you back in. We'll just see where we go next. So let me let you step back. If it's going to take more than 5 or 10 minutes, I'll let you go home. But I don't want to lose 20 minutes, frankly. If we can put that time to use. So don't form or express any opinion about the guilt or innocence of the defendant. Keep an open mind. You haven't heard it all, and I'll call you back in just a minute. Don't discuss the case among yourselves and follow my previous instructions. Step back to the jury room just for a moment. We'll Jury's absent. Upon the absence of the jury, and the statement of the prosecutor that the state has rested its case, the defendant through counsel may make such motions as are deemed appropriate. Will you be heard?
Yes, Your Honor. As to the charge of the first-degree murder of Laura Apperson that the state has alleged against Ms. Hayes, it's our position that the state does not consider sufficient evidence on each and every element of that allegation for it to advance to the jury. Their evidence is that they believe Laura was at the department on the evening of January the 13th, and that she was later, her remains were recovered in Texas. Ms. Hayes is charged with the first-degree homicide, and the state has, at least in jury selection, contended that their theory of the case was that Amanda and Grant acted with some common purpose to kill Laura, and that Ms. Hayes was present, in fact, when Laura was killed. And they've not presented any evidence as to Ms. Hayes' presence or non-presence at the time Laura was killed. In fact, where Laura was killed, it appears that there's evidence as to the cause of death is somewhere around strangulation, possibly stabbing, based on the anthropologist's testimony and the evidence of the medical examiners regarding their autopsies. But as to this client, as to Ms. Hayes, they have not presented any evidence of malice or intent or threats that they were able to present in Grant Hayes' case. No motive has been established, and certainly no circumstantial evidence that would tie Ms. Hayes personally to the death of Ms. Apperson or establish that she was present at the time that the death actually occurred.
Well, I mean, at this stage, the state is entitled for the court and the jury, well, the court here, based on this evidence, to accept as true for purposes of this ruling all the evidence in the light most favorable to the state. When the court does that, Amanda Hayes, by her own words, as I recall, she purportedly told her sister, I hurt her bad, I killed her. That is evidence from which the jury could infer that she in fact killed her. And
Statements in their totality. Ms. Berry also said that she asked if you're covering for Grant, and Ms. Hayes indicated that she was, and Ms. Berry found that to be credible and in fact believed her.
And it's for the jury to determine what those words meant. I understand that. There is sufficient evidence as a matter of law to allow that issue to go to the jury based at this point on the evidence before the court, before the jury, and therefore the motion to dismiss the homicide charge is denied. Okay, that motion is also denied. Will there be evidence for the defendant?
There will be, Your Honor. And let me say that our first witness, given the hour, we would recall Detective Falk for the purpose of playing the exhibits that we identified of Grant Hayes in the Raleigh Police interview room, the tape that accompanies that, and have him read the transcript along with the tape. Now the tape is like perhaps 6 hours long because there are long gaps, which we don't intend to play the whole thing. And frankly, you can barely hear what he's saying. It's the context of what he's saying that we want the jury to know, but we also want the jury to see his demeanor on the screen while it's being said. So we don't intend to take 6 hours to do it. We intend to take only as long as it takes to read the transcript.
Okay. Do you intend to call Grant Hayes as your witness?
No, we do not.
Well, then how do you get in the statements of Grant Hayes during the course of an interrogation of him?
It goes to his state of mind at the time that he is at the Raleigh Police Department, and as it pertains to Amanda's state of mind of what she's been perceiving of him over the last week or so.
How is it competent?
It helps to explain why she was in fear of him. You can see in the tape that he's not a rational man. And if he's not rational, then it explains her fear of him and demonstrates to the jury why she would be afraid of him.
How is it competent? How is it admissible evidence?
It goes to the state of mind of both.
Oh, I know what it goes to, but how is it otherwise admissible under the rules of evidence?
Well, we're not offering it for the truth of the matter asserted. We're offering it to show the state of mind of the two individuals involved. We don't contend that they're, as he said.
How is the state of mind after the offense relevant?
It's our evidence, we contend, will show that this problem has existed for some period of time prior to the time that he shows up in the Raleigh interview room.
Okay.
John, if I may, I would just put Mr. Gaskins in that some portions of the him videoed in the interview room do not involve him talking directly to law enforcement, or him acting in an erratic manner while he's in there alone.
Which proves what?
It proves that that video was taken very close in time to when they just got back from Texas to Kinston, and then they were arrested, and you've got, that's the best evidence, if you will, of the state of mind that Mr. Hayes was in the time contemporaneous when she was in his company.
I know of no basis for its admission. I'll be glad to hear you again if her state of mind at that time, at the time you're talking about, her state of mind at that time, which is what, 10 days after this alleged offense or more, on that date becomes relevant. But there's nothing about what's been said thus far in this trial that would make either Grant Hayes' state of mind 10 or 12 or 15 days after the alleged offense relevant to the charges for which she stands accused and for which he's been convicted.
Well, she stands accused not only of the homicide itself, but also as an accessory after the fact. And I would expect the state will contend that that accessory after the fact encompassed their travels not only to Texas, but from Texas, and any activity thereafter.
I understand. At this point, I fail to see the relevance of it. I certainly fail to see how it's competent in the rules of evidence as I understand it. And the request to, you can offer it for the record, the request to, its admission is the state object?
Yes,
Yes, I thought you had. The objection's sustained. It will be made a part of the record, but it will not be referred to until such time as you convince me later during your evidence that it's become relevant. I'll hear you again if you do. All right. What additional evidence do you intend to offer? Any?
We do intend to offer additional evidence, Your
Okay.
Honor. Our first witness that we would call would be Mel Palmer.
Okay. Ms. Palmer here?
Yes.
Okay, great. Ask Jury to come in, please. All right, we're back in session. The jurors are present. The state having rested its case and the state having completed the evidence as presented, the court will inquire of the defendant through counsel if there be evidence on behalf of the defendant.
Yes, sir. Your Honor.
Okay, you may proceed. Call your first witness.
Mel Palmer.
Mr. Palmer, come around. Be sworn, please, sir. You take your oath, please. Put your left hand on the Bible and raise your right hand, please, sir.
You solemnly swear the testimony you give this court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
You may proceed.
Ready? You ready?
Yes.
State your name, please.
My name is Mel Palmer.
How are you employed, Mr. Palmer?
I'm a licensed investigator in the state of North Carolina.
And how long have you been licensed as an investigator by the state of North Carolina?
Since 1986.
And tell us, what do you do in the way of investigation?
Generally, I get assigned to case matters throughout the state. They're generally first-degree capital murder or non-capital murder cases. My responsibility is to go out and locate witnesses and or re-interview witnesses that the state has already interviewed. Subpoena some witnesses, re-investigate where it's necessary through the attorney, and other matters that the attorney might want handled.
Now, would you tell us something about your
Background.
experience in the investigative field, both before and after you became an investigator, a private investigator?
I suppose my investigating experience started at, believe it or not, at age 17. I was in the United States Marine Corps here in North Carolina, assigned to the prison at Portsmouth, New Hampshire, as the sergeant in charge of investigations in the cell block, also in screening center and the control center. I left that job and returned to Philadelphia, joined the Philadelphia Police Department. And in the police department, I handled special cases: homicide, organized crime, rape, civil disobedience, and polygraph. I left the police department and went to the district attorney's office, where I was assigned to the same type units. And upon retirement, I came here to North Carolina and went to work with the state as a state agent. I left that job in '86 and took a license.
Now, were you asked to assist us in the investigation of this case?
Yes.
What specifically were you asked to do?
My area of responsibility was simply to operate a vehicle, a 2009, I believe, Dodge Durango, and trace the movements of that vehicle on or about the dates that this incident occurred to the places that are outlined in a chart. I believe the state had listed it.
You had their spreadsheet available to you, did you not?
Yes, I do.
And do you have that in front of you?
Yes. Yes.
You received possession of that Dodge Durango, if I am correct, on December 14th, 2013. Is that the right date?
That's correct.
Or not 13, 14?
On the
December
14th of December, 2013.
Of 2013.
Yes.
Okay. Now, while you were in that vehicle, did you go to the BP station to fill it with gas?
Yes, I did.
Now, let me, somewhere up there, someplace, is this spreadsheet that has previously been introduced into evidence. Your Honor, we would like to publish the spreadsheet on the screen.
All right. Do you have some way to do that?
Yes,
Okay.
Your Honor. I'm
Sure.
prepared.
Are you the screen guy?
Yes, Your Honor.
All right, good.
Madam Clerk.
Are you depicting a defense exhibit or a state's exhibit or both?
It's Defense Exhibit 37.
Okay. All right, defense exhibit 37. Are you moving the submission into evidence?
Yes, we are.
All right, let it be received, and it's, Jamie, wait a minute. Hang on.
Your Honor, we tried in the past, we're having technical difficulties.
Put your, you know, can you put yours up? All right.
Mr. Palmer, let me first direct your attention to the second item from the top. Do you see there that there was a trip to the BP station on Glenwood Avenue at 1:12 a.m. on July 13th, 2011?
That's July 14th, is it not? The 14th?
July 14th. The first one we see on July 14th at 1:12 a.m. You see that?
Yes,
Do you see that the amount, that's a gas station, isn't it?
yes,
Do you see that the amount of the purchase was $29.18?
that is correct. That amount is correct, 2918.
Now, is that where you began your driving of this vehicle at that BP station?
Yes, that's correct.
And did you fill the car up with gas before you began your drive?
I did.
Now, if you will, look on down the chart to July 14th at 10:41 p.m. A reference to the Kangaroo Station on Creedmoor Road. Do you see that?
Yes, 6317 Creedmoor Road?
Yes, sir.
Yes,
And do you see that the amount purchased on that day was $41.58?
that amount is correct.
And that's also a gas station, isn't it?
Yes, Kangaroo.
Go on down the list, if you will, to July 15th at 5:56 PM, and you see a reference to the Sheetz station in Wilson.
Yes,
That's also a gas station, isn't it?
that's correct.
Do you see that the amount that was purchased on that occasion was $33.64?
The amount is correct.
So we have a total of $104.40 of gas put in that vehicle during that period of time.
Objection.
Sustain unless you have evidence that that was to purchase gas.
What do you buy at a gas station?
I'm sorry?
What do you buy at a gas station?
Generally, you buy gas.
Have you done your calculations on the assumption that the purchases were for gas?
I'm sorry?
Have you done your calculations based on the assumption that the purchases were for gas?
Yes,
Do you know what the price of gas was in Raleigh? The average price of gas in Raleigh on during the week of July 13th, 2011?
well, at that time, gas would have been at $3.45 a gallon, 2011.
And how many gallons, doing the arithmetic, how many gallons of gas can you purchase at $3.45 a gallon if you buy $104.40 worth?
I'm sorry, say that again?
Let me do the arithmetic.
Yeah.
That helps. If you put $104.40 worth of gas in a vehicle,
Right,
at $3.45 a gallon, you are putting in that vehicle a total of 30.26 gallons of gas, correct?
that's correct.
Now, are you familiar with the specifications of a 2009 Dodge Durango?
According to the manufacturer,
Yes.
yes, about 27 gallons for that vehicle.
And how many, you get 20 miles on the highway, right?
20 on the highway, about 17 in the city.
Now, you drove this car, or this Dodge Durango, on the route indicated by the receipts that you have, correct?
That's correct.
And how many miles were you able to drive this car following the receipts and the purchases of gas and the bank deposits and the materials that were available to you to allow you to track this vehicle?
The total mileage,
The total mileage.
about 648 miles, I think it was.
Now, all of that isn't attributed to the receipts, the material contained in the receipts, is it?
Yes,
Do you recall getting lost for a little bit of time?
about 50 miles off track, 'cause I drove the vehicle.
Yeah.
Or about 50 miles over and above the mileage that we initially had.
So the total number of miles that you would have driven using 30.26 gallons of gas would have come to 597 miles. Am I
That's correct. And if you add 50 onto it, that's how we got to the 648.
Now, that trip involved 2 trips to Kinston, North Carolina, didn't it?
Correct.
Kinston and back, correct?
That's correct.
Approximately 90 miles each way.
To Kinston, yes, it is.
You made one trip to Kinston on Thursday morning, July 14th, 2014.
Yes, I did.
2013, I'm sorry,
13.
2013. You made one trip to Kinston and back.
Oh, wait a minute.
Objection.
No, wait a minute. I'm sorry. We're talking about 2014.
Now, we're in 2014 now.
Yes. You want to say that question again because I'm not hearing you correctly.
You had the vehicle on December 14, 2013.
That's correct.
And you, on that day, you drove drove it to Kinston and back, correct?
I did,
At a total of approximately 180 miles.
yes, round trip.
The next day, you drove it to the Sheets from Raleigh, to the Sheets Station in Wilson, North Carolina, and back. Is that correct?
That's correct.
A total of about 125 miles, am I correct?
125, correct.
Then you drove it from Raleigh back to Kinston, a total of about 90 miles, correct?
Correct.
And from there, you drove it to the Walmart at Briar Creek in North Raleigh, a total of about 105 miles, correct?
Yes,
Now, you went approximately 50 miles out of the way during the period that you were lost, correct?
yes.
You didn't count that during the 597 miles.
No, I did not.
Traveled, did you?
No,
And in order to travel the 597 miles plus the 50 miles while you were lost, it was necessary that you put approximately 33 gallons of gas into the vehicle, am I correct?
that's correct.
That would account for the 50 extra miles that you drove that you didn't need to be driving.
Correct.
So in tracking the person that was driving this vehicle, the miles that are attributed to him total 597 miles, am I correct?
Yes,
While you were in Kinston, or let's strike that, did you have available to you the comprehensive report for Grant Hayes III?
I believe I do have a copy. No, I don't have a copy of it.
Did you have a copy of it then?
Oh, yes. Here it is. I have one.
While you were in Kinston, did you go by and visit or view various houses that were titled in the name of either Grant Hayes III or his parents, Grant Hayes II and Patsy Hayes?
Objection to the leading and also the hearsay.
Overall, he can answer.
Yes,
Did you take photographs of those houses?
yes.
May I approach the witness, Sean?
All right.
May I approach, Sean?
Sure.
Mr. Palmer, let me ask you, if you will, to examine what I have identified as defendant's exhibits 113 through 119, and ask you if you can identify those exhibits.
Yes. Those are the properties.
And those are the properties that you visited and photographed were the properties identified in the comprehensive report, is that correct?
That's correct.
Your Honor, I believe we figured out how to work the screen, if we could publish those
Okay.
at
No
this time.
guarantees, Your Honor, but.
All right, well, do you have it marked as a defense exhibit, and do you intend to offer it?
Yes, I would like to offer those into evidence.
All right, let it be received, and you can publish.
If you will look, Mr. Palmer, the addresses are written on the back for convenience sake. If you would you look first at the address at 1505 Holman Street?
Yes.
Is that a photograph that appears on the screen of that address?
That's correct.
Were you able to determine that that is the home where Grant's parents live?
That's correct.
And going on to the next exhibit, 217 East Washington Street. Do you see that one?
Yes.
You recall that this is a business called Star Daycare,
That's correct.
and that's the daycare that is run by Grant's parents. Is that correct?
Yes, that's correct.
Going on to the next exhibit. Is this the resident? I believe you can see the numbers 307.
That's 307
Is
Cox.
that 307 Cox Street?
Correct.
Now, did it appear to you that this home was actually occupied by someone?
It did appear occupied.
And going on to 403 Cox Street?
Yes.
Is this a home that was directly across the street from 307 Cox Street?
That's correct.
Now, these were within perhaps less than 100 yards of the home at 1505 Holman Street, weren't they?
Yes.
Did this residence also appear to you to be occupied at the time that you were there?
It did appear occupied.
If you will, the other homes that you viewed and photographed were either on East Washington Street, or in the immediate area of East Washington Street. Is that correct?
That's correct.
Do you have a photograph for 510 North Independence Street before you?
Yes.
And if we could publish that. Is that appear to be that resident?
That is correct.
That did not appear to be occupied, did it?
No, it was not occupied. It's boarded up.
Did you also view and photograph a residence at 207 East Washington Street in Kinston?
Yes.
Does that appear to be that resident?
That's correct. That's the same person.
Now, did you see anyone at that residence?
There was no one there. However, there was a dog chained in the yard area of that residence.
And was the dog living in a dog house?
There was a dog house there,
But the dog was chained up,
but the dog is chained.
but you didn't see any people at that house?
No, absolutely not.
And finally, did you view and photograph a residence located at 211 East Washington Street in Kinston?
Yes, that was the last one.
Does that appear to be the residence that you photographed?
Correct.
Now, that residence has a for sale sign on the front of it, doesn't it?
Yes, that's correct.
Thank you, sir. That's all I have on that. Are you familiar with the manner in which individuals use a voicemail system to communicate with each other?
I've had some experience with cases where people have used cell phones or those throwaway phones, whatever they call them today. What you would do, if I wanted to contact either one of you, I would dial from my number to a call center and leave a message. But I need a code to get into that message center. I use the code, leave a message at the call center, and the person who I'm calling would call the call center and retrieve that message, and his number would not be shown.
Does it show, his number doesn't show up on the telephone records,
Correct.
correct? What shows up on the telephone records is the voicemail number.
Only the voicemail number.
So you can use the system to entirely bypass all telephone references to that telephone number, can't you?
Yes, you can.
And likewise, if you leave a message on your voicemail system, I, for example, can call your voicemail number and retrieve that message, can I?
Yes.
I can also leave a message on your voicemail system, can I?
Yes, you can.
And you can retrieve the voicemail message that I have left on my own voicemail system.
Right, if you have the code to
All
get
you
in.
have to have is the code, isn't it?
Correct.
And the only numbers that ever show up on any telephone records are the voicemail numbers, aren't they?
Yes, that's correct. The voicemail number and the number that you actually dialed from.
And if, in order to know what number you dialed from, police officers, for example, would have to know to go pull your cell phone number and pull those records, wouldn't they?
Just
Correct.
saw meeting, Your
Sustain.
If you, in other words, if you dial the
You can ask him how it works.
explain how it works if someone calls the voicemail system from their own cell phone number.
If I were calling from my cell phone number to anyone else, I would dial that number system, the answering system, leave the message after I enter my code. The person who was trying to retrieve that message from me would call that center, enter a code, and retrieve the message.
And the person who maintains the voicemail system would not leave his or her registered number on the phone records, would they?
That's correct. It wouldn't show.
The number that shows up is the voicemail number.
Correct.
Have you ever seen the movie The Talented Mr. Ripley?
Yes.
Have you seen the movie The Stepford Wives?
Yes.
They approach the witness on.
Sure.
you will, Mr. Palmer, to examine what I want is appended to 111 and ask you if you can identify that exhibit.
Yes, the talented Mr. Ripley.
Is that a movie in which Matt Damon plays the part of the sociopath Tom Ripley?
Correct.
And you have watched it how many times?
About 3 or 4 times
Let me ask you.
over the years.
Ask you also to examine what I've marked as defendant exhibit number 110 and ask you if you can identify that exhibit.
The Stepford Wives. I reviewed this movie about twice.
Now, there are actually 2 versions of the Stepford Wives.
That's correct.
This is the 2004 version,
Correct.
isn't it?
Yes.
This is the version in which Nicole Kidman, Glenn Close, and Bette Midler are the primary stars.
Yes.
Is this the movie in which Amanda Hayes played the part of an extra?
Correct.
At this time, Your Honor, I would offer into evidence plaintiff's exhibits numbers 110 and 111 and ask that they be placed in the jury.
Okay, I'm gonna send the jury home. Ladies and gentlemen, and I'll rule on this in your absence. We'll stop for the evening. Don't form or express any opinion about the guilty defendant or any matter in controversy. Be careful about your conduct following previous instructions. And we'll start at 9:30 in the morning. See everybody. Have a good evening. See everybody at 9:30 in the morning. Thank you. All right, jury's absent. Does the state object?
Yes.
Okay. What's the purpose of this evidence?
Your Honor, the 2 movies have been so closely tied to these individuals. Grant Hayes to the talented Mr. Ripley. Laura Ackerson recorded in her parenting history survey that he had told her that he was the talented Mr. Ripley. He has so closely identified himself with the character in this movie that the characterization of the main character in this movie displays in an extremely unique way how Grant Hayes perceived himself to be. As to the Stepford Wives, we know that Grant Hayes has indicated repeatedly that what he wanted in his life was a Stepford wife, and that he had met Amanda Hayes, who had played a part in the movie The Stepford Wives. And he has so closely tied her to the kind of character that he wanted to be married to, that it identifies her in a very unique way and ties her very closely to the characters played in the movie. Both movies are so interchangeably referred to in describing both Grant Hayes and Amanda Hayes that they simply cannot be separated from what they perceive, what Grant Hayes perceived each of them to be.
Mr. Gaskins, in that, as far as Laura telling us through the parenting history survey that Grant Hayes says, "I am the talented Mr. Ripley," that movie, Mr. Ripley in the movie does in fact kill people close to him and creates an elaborate web of deceit to hide that fact. And it's the purpose of our defense, if you, listen to our opening statement, that Ms. Hayes had in fact been married to a man who believed himself to be as talented as Tom Ripley exhibits in that movie in the same kinds of situations. Also, the references that Grant Hayes not only through Laura's recounting through the parenting history, but to his own statements about Calloway. She testified that he told her he wanted to marry a second wife, but also there will be evidence, if it's not already admitted, that he had intended to find a wife that he could control. And I believe through the parenting history, Laura makes that observation about Grant and Amanda, and that he met her and characterized her as his investor, and went on to make further remarks that once he got the money from her, then he divorced her, she would have to pay alimony, but clearly indicating that he believed Amanda was that easily manipulated. There is a case, we tried to find one in North Carolina, but we did find one from the state of Georgia, Supreme Court, 1998 case in which the prosecution was allowed to play a movie that the defendant had identified himself with in that case, the movie being The Natural Born Killer, I believe, because it's supposed to be aligned with an identity to that of this movie that the judge ruled irrelevant in that particular case. In our situation, because of the unique parallels to not only Grant's deceptions everywhere he's ever been. I mean, he tells Dr. Calloway that he's supporting everybody, and you hear evidence that was in fact not true. In fact, Ms. Elmer, Shea Goodat has already testified that he blamed her mother financially and sold everything she had. And so we've seen evidence of that deceit. Laura Ackerson has testified that her parenting history survey says she lied about everything, including what he had for dinner last night, when it came out through the parenting history survey. And we believe it would be prejudicial to Ms. Hayes not to allow the jury to see, the movies that depict the very person that her husband defines himself to be, particularly from the state's theory of the case, is that they somehow acted in concert. They tied them together to an acting in concert theory, and I believe that it is possible, and I believe it's the error not to allow the jury to see.
Go ahead. Says the state.
Your Honor, I see no relevance or probative value in showing this jury these two movies. Essentially what the defense counsel just told you is that the theme of the movie comports with what they believe to be the theme of the case. Just because the movie has a certain theme, I don't think makes it relevant. There's been no specific showing that this has any probative value in this case. And I would object to it on the grounds that it's a waste of time for this jury, and it gives this jury no evidence one way or the other to find that the facts are more likely than without this evidence. So I would object to it on those grounds, and the fact that it's probably looking around 6 hours long at this point. The probative value is far exceeded by the prejudicial value, I guess I would say, of having this jury sit there and watch a movie that's unrelated to this case.
Your Honor, I would respond in that it's not unrelated, in that Grant Hayes and Laura Ackerson and the parenting history survey have made it relevant. And we, as the defense, need to put on evidence, the best evidence that we can obtain, that would show the sort of person that Grant Hayes is. We can't evaluate him, he's not our client. And we've got, if he's saying, or at least Laura believes he's saying, that he is the character in these movies, and the same argument regarding his behavior in the interview room, even when he was not being interviewed, his behavior is very bizarre. and erratic, it goes not only to the fundamentals of our defense in this case, but also because it's linked not only to Grant identifies himself to be, and he is a major perpetrator in all of the state's case. I mean, they've got him running all over the place on video, most of the state's case, showing what Grant Hayes has been doing. They're saying 6 hours worth of our case would be a waste of time for the jury, but we've been here quite some time with the presentation of the state's case. And Ms. Hayes' state of mind as it would react to Mr. Hayes and the particular psychological makeup that he has is extremely relevant to this case. It is this case. It's the very reason we are in this case. But for Ms. Hayes marrying Mr. Hayes, she would not be broke and she would not be in this courtroom today.
Do you intend to call any kind of psychiatrist, psychologist, or anyone who's evaluated the history of Grant Hayes as set forth in all the information acquired during the investigation, all the information provided by Dr. Calloway, all the information set forth in the parenting history, and in addition, I guess, having looked at these films to give some opinion as to Mr. Hayes' mental state.
Your Honor, we would rely on the evidence that came in through Dr. Calloway regarding her observation of his illogical thinking, his rambling nature, his mood disorder, his disturbed thinking, and her recommendation that he see a psychiatrist, coupled with the very strong observations of Laura Appleton, but also Heidi Schumacher, who had first-hand observations of Mr. Hayes. Ms. Shea, Ms. Elmer, provided some insight into her observations, and we believe that the jury would be competent to make their own observations or come to their own understanding of the type of person that Mr. Hayes is and his ability to manipulate, dominate, and control, and deceive.
All right. So if someone says, I am the talented Mr. Ripley, then in order to figure out what kind of issues that person has, then the jury would need to look at the talented Mr. Ripley to figure that out. And that would be probative and helpful in the jury assessing what that person, who that person is.
Obviously, we feel very strongly about it based on the unique circumstances in this particular case. I wouldn't argue that in every case where there's some reference to watching a movie or a video game that it might be relevant, but we consider limiting this number of scenes or that sort of thing. But I do think when you've got a case where you've got an individual who has done the sorts of things that Mr. Hayes has in fact done that so closely parallel a character in a movie, we've heard evidence that he's killed someone else and got away with it, or at least he has told somebody that he has. That's before the jury. Ms. Ackerson, through her parenting history survey, made the same observation that he had told me he had told other people. And certainly those statements that have already come into evidence are, in fact, the sorts of things that Tom Ripley was responsible for in this movie. And created such a web of deceit to fool the people around him and close to him about his activities.
I'm going to sustain the objection to the. I'll allow the 2 movies in for the record only. I will not allow them to be played. However, I'll allow Mr. Palmer, who's seen the movie 2 or 3 times, to describe in depth the story of the movie, the plot of the movie, everything that you choose to ask him about what the movie's about, the character in the movie, and how it comes out and all that. But we're not gonna play the movie. All right. You look like you're gonna stand up.
Yes, Your Honor. I just wanted to be heard on one thing if this was the appropriate time. I don't want to belabor the court. I can be heard on it tomorrow, but we made repeated motions pursuant to 15A905 for the disclosure of any photographs or papers, documents, or anything like that the defendant intended to introduce in evidence, and we never received those pictures. And I just make that request again, that if the defendant has any other photographs or documents that they intend on introducing, I think it would be fair to allow us to see them.
All right. It does work both ways, folks. I mean, they've given you everything, as I understand that they have. That you're supposed to give them an opportunity to see your evidence too.
Obviously made along the way whether to put on evidence, and therefore have exhibits, but we do have some additional definitive exhibits that we.
Okay, that's fine. That's fine. All right. The objection sustained. However, I don't preclude the inquiry of Mel Palmer and his description of the movie that he's watched as part of his investigation. All right. Or movies, both of them. Anything else? All right. Sheriff will be in recess till 9:30 in the morning. Thank you.